being a Premier fund against Bank of Bermuda.
Mrs. Smith, can I raise with you one matter arising from your submissions yesterday in relation to contributory negligence? If you persuade us that Vesta was incorrectly decided, that doesn't mean to say that you're home and dry. There's a point that Mr. Gillis raises in paragraph 60 of his case at page 2371, which essentially is whether it's appropriate to overturn such a long-established decision.
Yes.
So are you going to deal with that at some point?
Yes. I'm happy to deal with that now. I mean, I think my primary response to that would be to say that the point made by the response there is quite an Anglo-centric way of looking at matters, if I can use that term. I mean, of course, as a matter of English law, Vesta and Butcher is part of the landscape. The question before your lordships is one of Cayman law. As a matter of Cayman law, there is no existing authority. I mean, your lordships are not actually being asked to overturn Vesta and Butcher. The question is, what is the correct interpretation of the Cayman statute? Mm-hmm. Now, when looking at what is the correct interpretation of the Cayman statute, obviously one takes guidance from what other common law jurisdictions and other common law courts have decided how they've analysed the point. And actually, your lordships are in a position where there's a number of different approaches in the different common law jurisdictions. You've got Vesta and Butcher, which is certainly one approach. Equally, you've got the Australian High Court in Astley and Austrust. You've also got, I think, what's probably a somewhat different approach of the New Zealand courts in the Court of Appeal in Rowan, Turner, Hopkins and Mowat against Clark Boyce. So I think, if I can put it this way, the respondent's point would have some force probably if this was the Supreme Court and we were on an appeal as a matter of English law, then that point would be engaged. In my submission, it's not really engaged when one is embarking on the construction of the Cayman statute. So, I mean, that's what we'd say. And technically, we're not asking your lordships to overturn Vesta and Butcher. I mean, that's not something we have to ask your lordships to do. It's not actually the exercise your lordships have engaged on.
Do you have any materials to explain why it was that Australian legislatures so promptly reversed Chief Justice Gleeson's decision?
No, we don't. I suspect we can find some because, I mean, there may be records of legislative debates within the state legislatures. I mean, as you'll have seen from the footnote in our written case, it looks like we know there was different legislation passed, I think, in each of the different states comprising Australia. I don't think we have at the moment any material that sort of records the policy debate, if you like, that underlay those changes.
Is this, I mean, it is a matter of, some significance. While you may be right to say that you don't require this court to disapprove of Vesta, but the existence of Vesta will have influenced behaviour, I imagine, in the Cayman Islands for a long period of time, even if it was not strictly binding there. And I think it would be helpful for the court to know what were the policy imperatives that gave rise to the reversal of Chief Justice Gleeson's decision.
Yes, well, we will identify what material we can in relation to that.
And just on this, we're looking, as I understand it, at the current version of the Cayman law, which is from 1996.
Correct.
So it postdates Vesta.
Correct.
So I was just wondering whether it might be said that since the Cayman law is so obviously inspired by English law, and this particular version of the Cayman law is passed after Vesta has become established as part of the English law, whether that affects the interpretation of this version of the Cayman law, or might do.
Well, I mean, it might be helpful to look at exactly what happened in 1996. I think there were no changes made to the parts of the legislation dealing with contributory negligence, which is my recollection. That the last changes to that were made in, I think, 1977, when you will have seen the definition of fault change. So whilst the law was, I think, technically revised in 1996, I don't believe there was any change or substantive change made in relation to the parts dealing with contributory negligence. We will double-check exactly what, if any, changes were made to the whole of the law in 1996, but I'm fairly sure nothing was done in relation to Section 8 dealing with contributory negligence.
What's going through my mind is whether it might be said that by repeating the law in 1996 at a time when the English version of the law interpretation had been declared in Vesta, the Cayman legislature might be taken to have, if you like, endorsed the law as so interpreted.
Well, I mean, I think I'd say that my submission in relation to that would be a bit of a stretch, I think, in order to impute that intention to the Cayman legislature. When you look at the nature of the exercise they were actually involved in 1996, which seems to have been merely a reissuing of the law without making any changes. And then, effectively one has to say, well, as part of that, they must have had in their minds a decision in a different jurisdiction and were effectively deciding positively to carry that through. So I think I'd submit that that's perhaps an unrealistic intention to attribute to the Cayman legislature.
Yes, thank you.
But I'll come back to you, if I may, on the question of what changes were made in 1996, just so we have the position on that clear.
Yes. But, sorry, just to pursue it a little bit further, presumably there was a review of the law of contributory negligence for the purposes of restating the law. So presumably the Cayman legislature would have looked at what the position had been arrived at in such a closely related jurisdiction as the English.
Well, I'm not sure that's necessarily right because, as I say, I think the law on contributory negligence may just have passed through from 1977 to 1996. I doubt it's, if I may say so, it's right to assume that they reviewed the law of contributory negligence prior to that. I mean, certainly there's no evidence of any materials, preparatory materials of anything of that nature that indicates such a review was undertaken.
And what changed in the 1996 law?
Well, that's the point at which I will double check and come back to you. It's just you also will appreciate that the 1990 the 1996 law and indeed the 1997 law has a number of different components within it. One of which is contributory negligence. It was also dealing with fatal accidents. There was other reforms to the law of tort as well. I mean, the other point I'm reminded of is a point actually the judge made. If you go to the judge's judgment, and this is paragraph 314 at page 176 of. So it's page 176 of the electronic bundle. It's paragraph 314 of the judge's judgment. And this is, I think, relevant in relation to the point my Lord Sales just made, because he deals here with the nature of the process of revision under the Cayman law revision law. And you'll see he makes the point that the process of revision does not permit any substantive amendment of the law. So if the process is being engaged in is a revision under the revision law, that doesn't allow a substantive amendment to the law.
Yes, but I mean, he does make the point at the end that the Cayman Islands law should continue to be interpreted in the same way as the English statute upon which it's based.
Yes, I mean that's what that's what he says. Yes, I mean I think we say, well, you've got to look at this point in relation to how you interpret Section 8.1 as applying to contractual claims at all. Obviously, wasn't a point that was advanced to the judge. We're dealing with that for the first time now. And as I say, I mean it's ultimately a question of construction of Section 8.1 as to what it as to what it means, but on the sort of narrow point of, well, can you attribute a change in the law in 1996 because of the process of revision and because that came post Vesta and Butcher?
Yeah, so it wasn't so much change in the law that I was seeking to put to you as that the position in English law was clarified in Vesta and Butcher.
Yes.
Prior to the revision, and effectively declared that that's what the English law had been throughout.
Yes.
And I'm just wondering whether it might be said against you that the fact that the revision goes through not changing the law with the legislature's eyes open as to, well, that's what the English law has been said to mean, could feed across.
In order to answer that, I think in my submission one would need to look at exactly what was revised in 1996.
All right, because you're going to help us with that.
We'll dig out the answer. But I mean, if for the sake of argument it was some completely different provision of the Act dealing with something else, then that point, if I may say so, may have less force.
Yes,
but we will come back on that with a complete answer. Now, so the other point I just wanted to pick up from yesterday, which I left open, was my Lord Kitchen's question about whether a letter was written to the judge on receipt of the draft judgment, pointing out that he hadn't dealt with the recklessness issue. We've dug out the letter which was written. We sent a copy electronically. As you'll see, we did write on the 4th of July 2017, and the letter identified two principal areas which were missing in the draft judgment. The first was the strict liability claim, and the second was recklessness as to deliberate concealment and also breach for the purposes of Section 37. So in other words, both Section 37(1)(b) and Section 37(2). And as we said in the letter, what was omitted was both the analysis of the legal question, but also whether there was recklessness on the part of the defendants on the facts of the case. And you'll see from that letter we did say to the judge it's obviously important in the interest of justice for the arguments to be dealt with. Now, and the second part of the letter identified where the relevant submissions had been made by both parties. Now, in response to that, we didn't receive a direct response. What we received was a second draft judgment, which included, at that point, the strict liability claim, and also the judge's finding on the legal question of whether recklessness was sufficient for deliberate commission of a breach. But the second draft judgments didn't deal still with the question of whether there was recklessness on the facts. So the way the judge left it was simply on the basis he decided it on the legal question and didn't supply any findings on the contingency. He was wrong on the legal question, on the factual issue of whether there was recklessness on the facts.
So one further question, if I may, arising out of that. May we take it that these written submission paragraphs to which you've referred, or to which reference is made here in the letter, do directly address the matters that you've now sought to draw to our attention?
Yes, I believe they do. I haven't been back and checked them overnight, but I believe that they do. And perhaps we can just double check that. I mean, if that's wrong, I'll come back to you and correct the position.
And could we perhaps just be provided with our bundle page references which correspond?
Yes, we will do that as well. Absolutely. So that's the position in relation to that. Now, I was then going to pick up where we'd got to yesterday, and I was on the third subtopic of the limitation question, and this is the question of construction of section 37.2, section 32.2 of the English legislation, and in particular the phrase facts involved in that breach of duty. That's what would be concealed, and therefore the question is, did Primeo know, or could it with reasonable diligence have discovered the facts involved in that breach of duty? Now, as we said, in our submission, you can read that narrowly as meaning simply the fact which is the breach, or you can read it more broadly as including the facts which relate to the consequences of the breach, including those necessary to assess whether the plaintiff has a worthwhile claim. In our submission, as a matter of construction, the latter interpretation is the correct one. And there's three broad points we make in support of that argument. The first is that knowledge that loss has been suffered as a result of a breach is crucial to the ability of a claimant to bring a claim for damages against a defendant. In the case of a tort claim, it's obviously a necessary ingredient in order for the cause of action to accrue. But also, in relation to a contract claim for damages, it's necessary for the claimant to know he has suffered loss and to have suffered loss as a result of the breach in order to be in a position to sue the defendant for damages for the breach, because he has to be able to aver that loss and damage has been suffered in order to sustain a claim for damages. So loss is crucial to the ability to bring a damages claim, whether it's in tort or in contract. Secondly, in our submission, the policy of Section 37 and Section 32 of the English legislation is to ameliorate, where it applies, the application of the strict limitation period by allowing a claimant a reasonable opportunity to bring the claim. What it's concerned with as a matter of policy is giving the claimant a reasonable opportunity to sue. Now, we get that statement of policy from two places in the authorities. The first is Lord Millett in Cave at paragraph 7, 3463. I mean, it's the second sentence of paragraph 7, where he identifies the policy behind provisions such as section 32.2. He says, in common justice, a plaintiff ought not to find that his action is statute barred before he has had a reasonable opportunity to bring it. So it's about giving the plaintiff a reasonable opportunity to bring the action. And the second statement of the policies is from the FII group test claimant case, and this time paragraph 228 at page 3991. And this is from the judgment of my Lords, Lord Reid and Lord Hodge. It's dealing this time with section 32.1c, but paragraph 228, first, section 32.1c, like the equitable rule which preceded it, necessarily qualifies as certainty, otherwise provided by limitation periods. It means that the 1980 Act does not pursue an unqualified goal of barring stale claims. Its pursuit of that objective is tempered by an acceptance that it would be unfair for time to run against a claimant before he could reasonably be aware of the circumstances giving rise to his right of action. So, again, in my submission, chiming with what Lord Millett had said in the earlier case, what it's about is giving the claimant, the plaintiff, an opportunity to bring the action from a point in time when he's reasonably aware of the circumstances which give rise to that right of action. And if one is talking about a damages claim, whether in tort or for contract, that must surely mean that damage has been suffered. Otherwise, how is a claimant going to bring the right of action? So that's the policy. And then the third broad point we would make is there isn't any basis for construing the relevant words in section 37(2) differently in relation to a tort claim for damages as compared with a contract claim for damages. Now, as we understand it, the respondents seem to accept that in the case of a tort claim, one would construe the words facts involved in that breach of duty as encompassing the existence of loss stemming from the breach. Now, if that's right, then logically, in our submission, the same words should be construed in the same way for the purposes of other claims, including a breach of contract claim. If you say that the facts involved in that breach of duty include loss for the purposes of a tort claim, well, why doesn't it also include loss for the purposes of a contract claim or indeed any other cause of action? Now, the respondents' response to that, as we understand it, is to say that the words are construed differently for a tort claim for damages as compared with a contract claim for damages. And that's because they effectively read those words, facts involved in that breach of duty, as meaning facts necessary for the accrual of the cause of action. And so the argument goes that in the case of a tort claim, loss and damage falls within the language because it's necessary for the accrual of the cause of action, whereas in the case of a contract claim, because damage isn't technically necessary for the accrual of the action, that doesn't fall within the same terminology. Now, in our submission, that's wrong, and there's 4 reasons why we say it's wrong. First, and most obviously, it's not what the language in the statute actually says. I mean, the statute doesn't talk about accrual of the cause of action, facts necessary for the accrual of the cause of action. Secondly, we submit that approach is inconsistent with the policy underlying Section 32 and Section 37, which, as I said, which is where the section is applicable to ameliorate the strict limitation periods by giving the claimant a reasonable opportunity to sue. And that depends on the claimant being reasonably aware of the circumstances giving rise to the right of action. And if it's a damages claim, it must surely mean that the claimant is aware that damage has been suffered. The third point is that it leads to the conclusion that the same wording in the statute leads to a different result for tort claims as compared with contract claims. And fourthly, in our submission, that this point isn't supported by the existing case law. Now, I'll come to the principal case in this area in a moment, which is a decision of the Court of Appeal in a case called Johnson against Chief Constable of Surrey. Just by way of preface to that, to date, the case law has drawn a distinction between, on the one hand, facts which are said to be relevant to the right of action, and on the other hand, facts which merely improve the prospects of success. So when we come to look at Johnson, the distinction they draw in that case is between a fact you need to plead and a fact which evidentially helps you succeed. It means your claim it looks more meritorious, you've got better prospects of persuading a court. Now, in our submission, that distinction isn't applicable in this case. We are not relying on a lack of knowledge of facts that evidentially merely improve prospects of success. We are relying on the fact that Primeo didn't know there was a worthwhile claim because all the time it thought its assets were being kept safe. Now, putting it another way, Primeo didn't know the relevant fact that it had suffered any loss because its assets had been misappropriated. And it didn't know that until Bilmis had collapsed. None of the cases in fact say that in the context of a claim for damages for breach of contract, the existence of loss and damage is not a relevant fact for the purposes of section 32.2. And none of them say it's not a fact that a claimant needs to know in order to know whether it has a worthwhile claim. Now,
can I just ask you, Mr. Smith,
yes,
you're obviously going to be some time on this topic. Am I right in assuming that you've decided to take rather longer in opening and allow yourself correspondingly less time
yes,
in replying?
Your Lordship's right. I'm very conscious I've got a allotted total time, and, your Lordship's quite right. Now, if we can just sort of turn to the case law, which I'll do quickly. There's just one case I think I need to take your Lordship's to, which is Johnson against Chief Constable of Surrey. It's at 4654 of the electronic bundle. It's a case involving an interesting set of facts. It was, in fact, a claim for false imprisonment by the plaintiff, who'd given evidence at the trial of the Guildford Four in support of one of the members of the Guildford Four, and who said that at around the same time he'd been wrongly arrested by the police in connection with another purported offence. Now, the difficulty he faced was that his arrest and imprisonment had taken place in 1975, but the writ wasn't issued until July 1991, following the quashing of the convictions of the Guildford Four. Now, plainly, he therefore had a limitation issue. His argument was that the grounds on which the convictions of the Guildford Four were quashed, namely the unreliability of their purported confessions, was relevant to his cause of action because he said it went to the state of mind of the police officers who'd imprisoned him. So he said, well, that's a relevant fact. Now, that was rejected by the Court of Appeal, we would say unsurprisingly. I just take you to the relevant parts of the judgment, 4656. In the middle of the page, you can see the submission that was made on behalf of the appellant plaintiff. And the argument that was thought to be made by Mr. Heitner was he said the crucial question is whether the police had reasonable cause to suspect that Miss Richardson, who was one of the members of the Guildford Four, was guilty. So he was seeking to tie the false imprisonment to the question of the safeness of the conviction of the Guildford Four, what the police knew, he said, about the improperly obtained confessions. But that was rejected. You can see the response from the defendant at the bottom of the page. Essentially, the response was, if we just pick it up 6 lines, Mr. Glasgow submits that the cause of action in false imprisonment is complete on the false imprisonment occurring, and all the plaintiff has to plead is what he has pleaded in his case. For the burden of proof with regard to reasonableness of suspicion on the defendant's behalf is upon the defendant. So essentially the point was, well, in order to have a cause of action which is complete for false imprisonment, you just need to plead the imprisonment. And then the question of reasonableness of suspicion and so on and so forth is a matter that falls for the defendant to prove. And that's effectively what was accepted by the Court of Appeal. If we go over to 4657, in the second paragraph, you get the key part of the judgment of Lord Justice Rose. For my part, I accept Mr. Glasgow's submission that in construing the section there's no middle ground between facts and evidence. It may be that the plaintiff's case following the quashing of convictions would be evidentially stronger and have a better prospect of success. But I'm unable to accept Mr. Heitner's submission that the quashing of the convictions adds anything to the plaintiff's knowledge of facts relevant to his right of action. Facts which improve prospects of success are not, as it seems to me, the facts relevant to his right of action. So what he is doing there is, and this is understandable on the facts of that case, is drawing a distinction between facts which go to the right of action, which are relevant to the right of action, and facts which simply make the case evidentially stronger. And it may be that in that case, evidentially, the case for false imprisonment would have been stronger following the quashing of the convictions. No doubt arguments could be made about the approach of the police. But as a matter of completeness of the cause of action, everything that had to be pleaded in order to establish the claim was known at the time in 1975. And there's a similar approach from Lord Justice Russell at the bottom of the page. He says, four sentences in, the right of action in this case was complete at the moment of arrest. No other ingredient was necessary to complete the right of action. And the final judgment was that of Lord Justice Neal, which was essentially to the same effect. Now, the distinction they draw there between facts relevant to the cause of action, facts which make the cause of action complete, and facts which evidentially improve the prospects of success, is not something that bears directly on the issue we're concerned with here. In our submission, the issue we're concerned with here is the question of knowledge of damage, and indeed the incurrence of damage for the purposes of sustaining a claim in breach of contract. Now, our submission is that even applying the approach of the Court of Appeal in Johnson, in the case of a claim for damages for breach of contract, it can't be said that the cause of action is complete without being able to plead the relevant loss and damages said to have been caused by the breach. Conversely, loss and damage is not merely a fact which can be said to improve the prospects of success. It's not in the same category as the matters the Court of Appeal were considering in Johnson as fell into that bucket. It is something that has to be pleaded. Loss and damage is something which must be pleaded in the particulars of claim in order for a claim for damages to succeed. And indeed, unless loss and damage is pleaded in the particulars of claim, a claimant couldn't obtain damages. And from a practical perspective, as well as a cost perspective, would have lost the litigation. Now, that approach as regarding damage as something that falls within Section 37.2 in our submission also makes sense as a matter of policy. The reason is this: if you accept the contrary argument, which is run by the respondents, where a breach of contract was committed deliberately, then time would begin to run against a claimant once it could be said of the fact it was aware of the facts giving rise to the breach, even if the defendant continued to conceal the existence of any loss or damage. So on the respondent's case, if it happens that there's a deliberate commission of a breach of duty, but the claimant knows that there's been a breach, but nonetheless loss is concealed from it, time would begin to run. And it's very difficult in our submission to see how that is right. So our primary submission is the question of loss falls within the ambit of the phrase in 37.2 facts involved in the breach, and therefore it's something which the claimant plaintiff needs to be aware of, or could with reasonable diligence have discovered in order for time for time to start running. Now, our alternative submission on this is to say, well, even if we're wrong about that, you have to look at the nature of the cause of action in contract, which was relied upon, which is relevant in the present case. We're concerned here with the position as against the custodian, the second respondent. And so far as the custodian is concerned, in our submission, the custodian's core duty was to safekeep the assets. That's the duty of a custodian. The most effective safeguards duty forms part of the provisions of the custodian agreement, allowing for the custodian to appoint a sub-custodian to perform that and the other duties under the custodian agreement. That's what the most effective safeguards duty is concerned with. If we could just go to the custodian agreement again at 449. I've already showed you this. The relevant provision of the contract is clause 16b. But it's very important in our submission to note the opening words of 16b. What 16b is concerned with is with allowing the custodian to appoint a sub-custodian to perform its duties under the contract. The duties of the custodian under the contract, of course, include, perhaps of paramount importance, the safekeeping duty. In other words, the duty to safekeep the assets. Now, given that the core obligation of the custodian is to safekeep the assets, then it's difficult in our submission to see how there could in any event be a cause of action against the custodian if the assets in fact remain fully protected and safe in custody and the custodian is able to return them on demand being made. I mean, one can test it this way. If one sued the custodian for breach of clause 16b and one claimed damages, well, the response to that inevitably would be, why are you suing me? My duty is to safekeep the assets, and the assets are kept safe. You haven't suffered any loss. How do you have a sustainable claim against me? So in relation to the position of the custodian, the gist of the action is the failure to safekeep the assets. Or put another way, the essential promise is to keep the assets safe. And until such time as the assets have been lost, and the claimant knows that the assets have been lost, it's very difficult in our submission to see how it can be said there is a right of action, or that the claimant should know there's a right of action. Now, in the present case, it's not disputed that at no time prior to December 2008 did Primeo know that its assets had been stolen by Bilmis. And we say it follows from that, inevitably, that at no time prior to then was Primeo in fact in a position to bring its breach of contract claims. If it didn't know its assets had been lost, then it wasn't in a position to bring its contract claims against both respondents. So ultimately, whether one looks at the position in terms of saying, well, loss is a necessary part of facts involved in the breach, which the plaintiff claimant needs to know in order to start time running, or if one says, so far as the custodian is concerned, actually the gist of the action, the essence of the promise is to safekeep the assets, one ends up in the position in my submission that unless loss has been suffered and unless the plaintiff knows loss has been suffered or with reasonable diligence can discover that, time doesn't become running again for the purposes of section 37.2. Now, just finally on this point, those are our primary submissions. That there is also, in our reply case, paragraph 145, page 2355, two further points which we would make, and I accept these are points which arise on the facts. The first in subparagraph 1 is simply that there is no evidence that Primeo was aware of the issue of the custody confirmations, the fact they were issued wrongly by the second respondent. And then the second is the question of whether in any event Primeo knew that the second respondent had not taken any steps to comply with its most effective safeguards duty, which, as you'll have seen, is the clause 16.b duty. If I can just add a couple of points by way of amplification in relation to that. As I submitted yesterday, it's very important to have in mind that the judge said that the relevant breach by the second respondent on the facts was a failure to recommend the implementation of the relevant safeguards. So the breach was a failure to make the recommendation. Now, it's common ground, and in any event clear, that the second respondent did not in fact make any such recommendation or tell Primeo about the available safeguards. Now, what we're therefore concerned with is an omission to do something. The breach in this case consists of an omission. Given that the breach was the omission to recommend the implementation of the safeguards, in our submission it's difficult to see how Primeo could have been aware of the breach unless it was aware of both the fact that the recommendation wasn't made, but also aware of the fact that the second respondent was under a duty to make the recommendation. I mean, if the breach consists of a failure to do something, you can only be aware of the fact that it is a breach if you both know that the thing hasn't been done, which almost by definition you will know, but most importantly, you have to know that the other party was under a duty to do that act. And there is no evidence, and the judge makes no finding, that Primeo knew that the second respondent was under a duty to make the recommendation. There's no basis also to suggest Primeo knew what the most effective safeguards were available in New York, that it knew, and it knew specifically that the second respondent was under a duty to make a recommendation in relation to those safeguards, and that it had failed to comply with that duty. So on that question as well, we respectfully submit there isn't a basis, even if one looks at it very narrowly in terms of breach, so far as the second respondent's concerned, that there was a basis for saying that Primeo knew, or with reasonable diligence could have discovered everything it needed to in order to bring the right of action. Now, my Lord, that's limitation. There's then happily and finally a short point on the question of assessment of damages. As we say in the written case, it's a short point. It may nonetheless have a significant impact on damages. The context in which this point arises is as follows. The original custodian agreement was entered into between Primeo and the second respondent on the 21st of December 1993. And Primeo began placing investments with Bilmis shortly after this, in January 1994. Now, Primeo's pleaded claim against the second respondents sought to recover in respect of investments placed with Bilmis from that date, in other words, the January 1994 start date. And the evidence of the quantum experts at trial addressed quantum at that basis. On that basis, they effectively took January 1994 as your starting post, as it were. The respondent's position at trial was to deny that the second respondent had been the custodian for the investments placed at Bilmis at any time. So we said they were custodian from January 1994. The respondent said we were never custodian. At trial, the judge in effect agreed with neither party's case on this point. He concluded that the second respondent became Primeo's custodian in respect to the Bilmis investments, not in January 1994, but in August 2002. And that was the point in time at which the second respondent had formally appointed Bilmis as its sub-custodian under a sub-custodian agreement. So effectively, the judge came to a conclusion, as he was entitled to do, which didn't reflect either party's case as was advanced. Now, as a result, if we'd been successful on our claim before the judge, it would have been necessary for the quantum experts to prepare fresh calculations, because they'd have to look at the position by reference to a different starting point, not January 1994, but August 2002. Now, that's as matters stood following the first instance judgment. In their respondent's skeleton argument for the Court of Appeal, the respondents then sought to argue before the Court of Appeal that if you took August 2002 as your start date, then there was no net loss suffered by Primeo between August 2002 and May 2007, when the Herald transfer took place. And they came to that conclusion effectively by taking that time period and adding up the investments that went in against the redemptions that came out, and saying, well, aha, you've got a negative figure over that period because your redemptions exceed your investments. Now, that point, as I say, hadn't been pleaded. It only arose in light of the judge's finding in relation to August 2002. We would also say, we do say, obviously, that that point, the assumption underpinning that point is unrealistic, because what it assumes is that a redemption made in, say, September 2002 is attributable to an investment made in August 2002 and not an investment that was made, say, in May 2002. What it assumes, what it takes as its premise is you can effectively look at that period of time in a silo and assume that the redemptions tally with the investments made during that period. In practice, we would say if you've got a redemption in September 2002, that almost certainly relates to an investment that may have been made many months, if not years, earlier. So that's effectively the debate which arises out of the way in which the judge decided it. It arises out of the point the point sought to be advanced. Now,
Mr. Smith, sorry,
yes.
Can I just check
Yes, of course.
how you put your case when you were claiming loss from January 1994?
Yes.
My understanding was that you start January 1994. Do you finish 1st of May 2007 with the Herald transfer?
Yes.
So that's what you were looking at.
Exactly.
And because it covered the whole period of your investments, your claim, as I understand it, was actually to look how much you put in, less all redemptions in that period. So,
Exactly.
So when one was looking at the whole period, 1994 to 2007, you were happy with that sort of net input model. But what you're saying is that it breaks down as a simple model because the judge has gone for a halfway start point, and that creates a problem about how you apportion the later investments and redemptions.
Yes.
Well, sorry, redemptions specifically.
Exactly. That's exactly right. If you're looking at the whole gamut, it doesn't become an issue. When you take a period within the whole chronology, you get these issues about apportionment. That is precisely the point. Now, as a matter of law, we argued before the Court of Appeal that this new point was wrong. And essentially, there's three reasons we say it's wrong. One is what we call the running account point, which is you have to calculate the loss on a running account basis, effectively applying the rule in Clayton's case. So when you get a redemption, the ordinary rule, at least as a prima facie presumption, is you apply it to the first investment. And the Court of Appeal have said we're entitled to run that case if it goes back to the Grand Court. The Grand Court will have to decide that as part of dealing with quantum. We also say, secondly, that Primeo had the right to appropriate the payments. That's the appropriation case. It's also accepted by the Court of Appeal that that's open to us. But they said we were not allowed or we shouldn't be allowed to run our third case, which is what we've termed the assumption of responsibility case. And the argument there is that by becoming custodian, as at August 2002, the second respondent agreed that it had custodial responsibility for the assets it was representing were within its custody at that point. We call that, as you will understand, the assumption of responsibility. Effectively, the argument is they accepted responsibility for safekeeping of these assets. They represented that they were in their custody, therefore they're responsible for them. They're to be treated as custodian. Now, that point, the Court of Appeal said, was not open to us. And in our submission, that was wrong. Essentially, there's, I think, really just 2 points which really follow from the procedural chronology I've just described. The first is, given the way in which this part of the case developed, in practice, the first time we had the opportunity to advance this argument was in the Court of Appeal, because it only arose out of the judge's finding in his judgment about the August 2002 date, and then the respondents taking the no net loss argument in response to that. And in our submission, it would be unjust to preclude Primeo from running part of its case on quantum in circumstances where that arose in effect for the first time following the judgment. And the second point is that given the judge's decision on the custodian issue, in the event Primeo is successful in establishing liability, it is going to be necessary for there to be a further hearing before the Grand Court. And the Court of Appeal recognised that in paragraph 227 of their judgment. And they said if Primeo had been successful in establishing liability, it will go back to the Grand Court to deal with quantum. And they also accepted, as I indicated, that 2 of our 3 arguments on this area of the case would be open to us. And if that's right, well, in our submission, it's difficult to see why we shouldn't also be allowed to advance the third argument as well. So on that point, we submit they were wrong, Court of Appeal was wrong to shut us out. We're not asking your lordships to decide that point substantively. Effectively, it's a procedural point, and our submission is that if we're successful otherwise in establishing liability as the overall result of this hearing before your lordships, that ought to be one of the points included within the scope of what is remitted to the Grand Court. So, my lords, unless I can assist you any further at this point, those are our submissions in support of the remaining parts of our appeal.
Yes, thank you very much, Mr. Smith. Mr. Gibbs.
My lords, my learned friend has spent about 5 hours opening his appeal on the 3 issues of contrib, limitation, and assessment of damage assumption responsibility. As you will have seen, I've got a lot of issues that I am raising on my cross-appeal, and despite the importance of the contrib and the limitation issues, I'm not going to be able to spend the same amount of time as my learned friend has. I'm going to aim to deal with the question of Vesta and Butcher and then limitation, hopefully in about an hour for each of those sections. But if, as a consequence, my submissions seem somewhat abrupt, I apologise in advance for that.
Your written submissions will certainly not.
Okay, can I start with my learned friend's first round of appeal? Vesta and Butcher. Is it right? And in our submission, Primeo's case is both bold and wrong. Can I make 3 points as to why we say it's bold? Sorry, I should have said we deal with this in paragraphs 99 to 62 of our case, which is at page 2357. So Vesta is a decision of 35 years standing. In establishing that contributory negligence is available as a defence in cases of concurrent liability in contract and tort, it established a point of central commercial importance to contract law. It has no doubt been applied many thousands of times by the courts up and down the land in this country and elsewhere. It's an established feature of the legal landscape. There's practically a generation of lawyers who have grown up on the basis of Vesta and Butcher. Let me just give you two very quick examples. Even just in the context of auditors' negligence cases, one thinks of the collapse of Barings Bank, MS 3052, where in a claim against the auditors, Barings management was held to be 80% contributory negligent. And as recently as the Supreme Court's 2020 decision in Manchester Building Society and Grant Thornton, the Supreme Court upheld a 50% finding of contributory negligence in a contractual auditor's negligence claim. In terms of what's the legal significance of this, well, at paragraph 14, and it's picking up the point Lord Reid made this morning, so that's paragraph 14 at page 2360, we refer to the Supreme Court's comments in the franked investment scheme, and that's at paragraph 239, MS 3994, where the court said this: the court will bear in mind the damage of disturbing retrospectively the basis on which contracts have been entered into. On the question of whether contributory negligence is available as a defence in cases of concurrent liability, we suggest that that is a factor that ought to weigh very heavily with the court.
May I ask for your assistance on one point? How is the court to assess how much weight should be attached to this factor? And what balancing act are you inviting us to perform, and how should we perform it?
Well, I think that it depends upon the extent to which the court is of the view that parties' conduct will have been affected by the law having been established in this way. And we would say, if you're looking at it in that way, the fact that Vesta and Butcher has been the law for the last 35 years means that people haven't had to deal with this point in cases of contract. I mean, I'll come back to arguments in relation to freedom of contract later on. But equally so in the context of, let's say, insurance, of professional negligence claims. No doubt the fact that in many of the professional negligence claims there has been a significant finding of contributory negligence, that's something that would affect the insurance market.
So it's not limited to the effect of parties. It's a much wider scope than that.
It's certainly here we're talking about the general law. This is not an issue as between these parties. It's a matter of certainty of contract. And one sees principles of certainty of contract feeding through as to how one approaches questions of construction, because the court recognises the importance of certainty. And English law puts a premium on that. And we would say this, again, is such a case.
How are we to inform ourselves on the basis of the materials that we have at the moment as to these very broad questions?
My third point is going to be to take you to the Law Reform Committee's report, which specifically considered this point. So in terms of legal significance, FII, and we also rely upon what Lord Carnworth said in R. and Lewisham, LBC, which is UK Supreme Court 62, paragraph 95, and we have that supplementary bundle 291, that settled practice may be, in appropriate circumstances, a legitimate aid to statutory interpretation. The second reason we say it's a bold decision is because it's based primarily on the Australian High Court decision in Astley and Austrust. But as we point out at paragraph 45 of our case, that's MS 2369, that decision was very badly received, and its effect was promptly reversed by statutory amendment to the relevant Australian state and territories' contributory negligence legislation. And we say that hardly provides an auspicious basis for suggesting the reversal of a long-standing rule such as Vester and Butcher. The third headline point, and coming back to my Lord Jones' intervention, we say the challenge is bold because of the findings in the Law Commission's 1993 report entitled Contributory Negligence as a Defence in Contract. And, my Lords, we have that report, MS 9927, and the relevant part that I need to go to is at page 9955. So to put this in context, there was a Law Commission working paper in 1990, and they invited respondents to comment on the proposals that they were making. And at the top of page 9955, in relation to Category 3, the respondents were asked to give their views on VESPA Category 3. No respondent thought that apportionment should be excluded in Category 3 cases. It was acknowledged that it would be undesirable to have contributory negligence as a defence in one cause of action arising out of the same facts and not in another. And that, your lordships can see the respondents to that report. They are wide scale. And in the light of that, and I hope that responds to my Lord Jones's observation and possibly Lord Kitchen's comment in terms of impact on the wider society, no one was suggesting that Category 3 of Vester and Butcher was wrong or needed to be changed.
And sorry, where do we pick up, just for a page reference, the respondents? You said they're widespread. If we could have a page reference at some point.
It's in one of the appendices. I mean, there was even a separate section, if I remember, on the specific aspect of banking. But we'll find that. My lords, my learned friend said this morning that he was not, in fact, asking the court to overrule Vester and Butcher. And he tried to suggest that this was actually just a point of Cayman law. There's no force in that suggestion. Your lordships have seen the legislative history, and the 1964 Act was directly based on the 1945 English Act. So that's its pedigree. I'll come at a slightly later stage to the points my learned friend tries to make about the 1977 revision. But just focusing on where we start, this is all based on English law. And certainly, so far as I can recall, at the trial, nobody suggested that contributory negligence in Cayman had anything to do with any system of law other than English law. So you are being asked to overrule Vester and Butcher. There's no difference on this aspect between English law and Cayman law.
Yeah, and under Willers and Joyce...
I'm sorry, my lord?
Well, I'm just thinking, I mean, Willers and Joyce clarified the precedential status of decisions of the board on matters of English law, which this would be, and it would clearly be an important authority in the English legal system.
Absolutely.
Incidentally, I see the list of respondents is on MS 9990 and the following page.
I'm obliged.
And it includes, for example, the ABI.
Yes. And this is memory, but I thought there was even a separate section on banking and whether there ought to be separate provisions in relation to banking. My Lord, that's why we say it's bold. Why do we say it's wrong? Why do we say my learned friend's submissions are wrong? And I'm going to make, hopefully, short submissions on 5 topics. Firstly, the correct approach to construction of the 1945 Act. Secondly, the correct construction of the Act. Thirdly, the suggestion that Vesta has been impliedly overruled. Fourthly, the Commonwealth position. And fifthly, policy considerations. So can I start with the correct approach to construction of the 1945 Act? And the starting point is a point that Lord Reid made, that the law of negligence has changed since 1945. And we made the same point in our case, where we refer to what Mr. Justice Phillips said in Yule and Bland Welsh. That's actually better known as the Superholds case. And we quote that at footnote 5 of our case at page 2360. Where Mr. Justice Phillips, we suggest, made the very pertinent observation to attempt to find a solution by considering the result a 1990 situation would have produced under the 1944 law. I think it's unsatisfactory. The law of negligence has advanced since 1945, and the problem is how to apply the 1945 Act, having regard to the changes that have occurred. And we suggest that that is absolutely right, and the answer to be found is not as suggested in Astley, by looking at the clanking chains of forms of action, but by looking at how the law has developed. And it's because we take that as the starting point that, as you will have seen, in paragraph 11 of our case, we advocate 2 possible approaches to the question of construction. First, what we have termed the same-day construction, namely how the Act would have been understood at the time it was enacted. And then secondly, the always speaking, or the updating construction. And in that context, we refer at paragraph 25 of our case, MS 2364, to what Lords Reid and Lord Hodge said in the FII case. So, can I, and just to remind your lordships as to how the law has moved on, and we deal with this at paragraph 26 of our case. But it's worthwhile reminding oneself that in 1939, the established view was that a solicitor's liability could only arise in contract. That was Groom and Crocker. So it was before the establishment of concurrent liability as recognised in Hedleyburn and Heller and brought to fruition in Henderson and Merritt. So, my lords, if I can start with the same-day construction, which we say is relevant to how Parliament would have understood the letter.
Can I just mention, before you get really into it, the approach adopted by Mr. Justice Phillips is one that's easier to fit with the wording of the English Act than arguably it is with the wording of the Cayman Act. because the English Act defines fault in this context as negligence, etc.,
Yes.
which would, apart from this Act,
Yes.
give rise to the defence of contributory negligence, whereas the Cayman legislation talks about prior to this Act would have given rise.
And I'll come to that. And I'm not going to try and suggest that negligence can be read separately from all other giving rise to liability and tort. For the exact reason your Lordship pointed out, that statutory duty can't stand alone. So the argument that I'm going to be, so I'm not relying upon that disjunctive
No,
approach.
it's rather the temporal point, that the English legislation is couched in the present tense, whereas the Cayman legislation, just the way it's drafted, instead of saying, apart from this Act, give rise to, which is the English wording, or UK wording, in fact,
Yes.
the Cayman Act says, which prior to the operation of this Act would have given rise to. Prior to being, well, one then has to decide whether it's prior to 1996, 1977, or what.
Yeah. Well, I see that. We say that's a distinction really without a difference, and that when one looks at the legislative pedigree, it's quite clear that what is being intended.
Is there room for an updating structure? Is there room for an updating construction when the legislation itself is pinned down by these words to one particular point of time?
Look, I'll come to that in a moment, and in our submission, that's very much a consequence of how we see the law developing. So if I can just start by what we say in relation to same-day construction and how the matter would have been understood in 1945. My lords, the basic point that we try and make is this, that in 1945, the law's understanding of concurrent liability in contract and tort was still developing. That terminology was certainly not deployed in the way it is now. But even in 1945, the overlap, at least in certain cases, such as employer's liability and common carrier cases, was understood, and it was appreciated that the defence of contributory negligence could not be defeated simply by pleading the case in contract. Now, as I'll hope to show you, overlapping jurisdictions between tort and contract were understood. In the context of contributory negligence, the solution they provided was slightly different. They just regarded it as being a claim in negligence. What we say, coming back to my Lord Jones's point, is that when you appreciate that that's what's happening, the updating construction is entirely appropriate, because when you look at the essential issue the legislature was considering in 1945, it would have applied, or did apply, the defence of contributory negligence to cases of concurrent liability. So, my Lord, we say that that's the background against which the 1945 Act falls to be interpreted. And we say it's a much more nuanced question than suggested by Primeo and by my learned friend, because even during my learned friend's submissions, he frequently said that contributory negligence pre-1945 was not recognised as a defence to a claim in contract. Well, of course not. I mean, that's still not the law, but that's not the question we're addressing. The question is whether it was recognised as a defence in concurrent liability claims, And we say that the employer liability and the common carrier cases show that it was. So, my lords, in terms of what we regard as being the clearest statement to that effect, could I ask your lordships to look at Lord Justice Beldam in Barclays Bank and Fairclough Brothers, which we have at MS 3031. And it's the passage at MS 3045, and it's at letter B, at 229, opposite letter B, in 1945, actions brought by an employee, whether framed in contract or tort, were usually regarded as actions in negligence, and the defence of contributory negligence was by no means uncommon.
Sorry, 3045.
3046.
3046, thank you.
And then, secondly, a similar point was made by Lord Justice O'Connor in Vester and Butcher, which we have at MS 4118, and it's at letter D. And this was in response to an observation by Mr. Longmore, the counsel, as he then was, where he was submitting that contributory negligence was available in tort, but not contract. And Lord Justice O'Connor observed, if this contention is sound, then the law has been sadly adrift for a very long time, for it would mean that in employers' liability cases, an injured employee could debar the employer from relying on a contributory negligence by framing his action in contract. And for the purposes of establishing how the law was understood in 1945, at paragraph 22 of our case, which we have at page 2363, if I could ask your lordships to turn that up. We refer to an article by Professor Steele, and if your lordships have time, I would thoroughly recommend reading it. It's a wonderful piece of academic research and looks at the relationship between the Workmen's Compensation Act, obviously raising questions of contractual claims, and contributory negligence, and the difficulty that existed in getting this legislation through the coalition wartime government. And one of the issues that she looks at is why in the proviso to the bill, which originally said the bill shall not operate to defeat any defence arising under a contract, why that was removed. And if I can pick up halfway down, the second version of the first proviso, drafted by a small committee and put to the House of Lords, stated under Clause 1, shall not apply to any claim in contract and shall not operate to defeat any defence under a contract. The first part was eventually dropped. It seems worth exploring the discussions between the drafters on this point, because it has been asked relatively recently whether the application of contributory negligence ought to be extended to contractual claims. The drafters were clearly alive to the problem which could be posed by their proviso for cases which would now be expressed in terms of concurrency. Rejecting a suggestion that the reform should be expressly confined to claims in tort, Lord Simon is recorded as having pointed out that many claims for damages for personal injuries were laid both in tort and as a result of breach of contract to carry safely, and a plea of contributory negligence could be raised, which, if successful, would defeat the plaintiff. And he expressed a fear during the parliamentary debates that if the contractual proviso was read too broadly, his reform would end up applying only to cases of tort between parties who were strangers, e.g. two colliding motor cars or a running down case, and that it would be argued that it has no application at all where there is a contract between the parties, e.g. a railway ticket. It was for these reasons that the first part of the proviso, shall not apply to claims under contract, was deleted. The limited proviso was very carefully chosen with concurrency in mind. Now, I should make clear that what is being referred to there is from documentation sent by the Lord Chancellor to the parliamentary draftsman. And my learned friend, I suspect, will say that this is not admissible evidence. We say it is because I am relying upon it for the purposes of establishing the fact as to the understanding of how the law operated. And it simply articulates what we already see from the references that I've given you by Lord Justice Bedlam in Barclays and Lord Justice O'Connor in Vesta and Butcher.
There's a very strong statement by...
I'm sorry.
There's a very strong statement by the Supreme Court in the Welsh agricultural wages.
I think it's re-agricultural sector.
Yes.
Yes.
But I think one could legitimately take from this, at any rate, that Lord Simon, who would be familiar with the law in 1945, if anyone was, is telling us that it's a source of evidence simply that concurrent liability, what we would now call concurrent liability, was well recognised in 1945.
That's all I'm relying on it for, and so I'm obviously not relying upon it for Professor Steele's comment that that's why the proviso was removed. That's her opinion. We say that's obviously right, but for present purposes, all I'm doing is relying upon this for the purposes of establishing the fact of how the law was understood by somebody as eminent as the Lord Chancellor at the time. And I mean, if I had the time, it would be lovely to sort of take you through Professor Steele's article, because the Labour Party were very concerned with how the contributory in this Act might impact on workmen's claims. And so they were looking in that context at how this Act was going to impact upon contract claims. And that's actually all part and parcel of the background. So they were undoubtedly aware of this issue in relation to concurrent liability. And we say that that is how, as a matter of same-day construction, the matter has to be approached. Now, we accept, and we accept this in paragraph 18 of our case, that's page 2362, that the primary focus of the Law Revision Committee's 8th report in 1939 was tort. However, by the time the bill was enacted in 1945, in significantly different terms, and I'll expand upon this in a moment, the legislature were clearly aware of the much more nuanced relationship between concurrent contract and tort claims, and the fact that contributory negligence was available effectively as a defence where there were concurrent liability claims. My Lord, if we're wrong on that, since the question of contributory negligence in concurrent liability claims can no longer be dealt with simply by treating them as if they were claims in tort, we say the always speaking principle, as articulated in FII, and we have that page 2364. The always speaking principle requires the court to ask whether it is or was, quote, within the scope of the original intention of the Act, close quote, that concurrent claims in contract and tort should be within the scope of the Act. And we say that the answer to that is obviously yes. Because we can see that's what was being achieved pre-1945 simply by treating concurrent claims as if they were claims in tort. And in this context, we also rely upon what the respondents to the Law Commission's 1993 report said, which I've just shown you, there is no justification for contributory negligence being available as a defence to a claim in tort, but not to the concurrent cause of action that arises on the same facts. Now, my learned friend said that he had 3 objections to the application of the always speaking principle to this Act. He said it ignored the mischief of the Act. He said it would extend the Act beyond what was intended, and he suggested that it assumes what it seeks to prove. None of that's right, because of how I have explained the law has developed. And that if you are looking at what was the original intent, it was quite clearly the original intent that contributory negligence should be available and was recognised in effect in the common carrier and the employer liability cases.
Can I just ask, so sorry, just picking up from what you said about the relevance of Lord Simon's views, presumably there are legal texts from the 1940s or thereabouts that make these points.
We've not managed to find anything, and that may be remiss on our part. Can I deal with that at this stage? So Astley, Chief Justice Gleeson, was saying that there are no reported cases of contributory negligence arising as a defence to a claim in contract. We put the point around the other way. Where are the cases where there was concurrent liability in contract and tort? The tort claim failed because of contrib, but the contract claim succeeded. And we sort of threw down that gauntlet, as it were, to my learned friend in our case and said, where are these cases? And we've not found any. And so, fascinating though the legal history to all of this is, and I fully agree that one would expect that there were sort of more immediate points, or more immediate references. In a sense, one can see from Glanville Williams' writing that there wasn't. You know, he was having to look at a whole host of cases. He wasn't able to say that this is quite clearly established law. My lords, I'm not going to try and argue whether Glanville Williams was right in relation to all of those cases. I mean, I simply don't have time for it. What we say is the far more important point is that if you look at these classes of cases and what Lord Simon was saying, it was quite clear that, in effect, contrib was recognised pre-1945 as a defence to concurrent liability claims, but that was done through the somewhat crude mechanism of just treating it as a claim in tort. My lords, can I turn to the second topic, the correct construction of the Act? And the parties are agreed that ultimately this is a question of statutory construction. Can I just start by taking you back to Vesta and Butcher? And we have that at manuscript 4124. And it's at page 4123, Lord Justice O'Connor starts by quoting from what has become the very influential decision of Mr. Justice Pritchard in the New Zealand case of Rowe and Turner. What I'd ask your lordships just to concentrate on, which my learned friend didn't concentrate on specifically, is how Mr. Justice Pritchard concluded his analysis. And we see that at page 4124, picking up just above letter C. I therefore conclude, in the absence of any clear authority to the contrary, that the first limb of the definition of section 2 determines the meaning of the word fault as it relates to the plaintiff's cause of action, that accordingly, Contributory Negligence Act cannot apply unless the cause of action is founded on some act or omission on the part of the defendant which gives rise to a liability in tort. But if the defendant's conduct meets that criterion, the Act can apply, whether or not the same conduct is actionable in contract. By the same token, the second limb of the definition means simply and logically that no act or omission of the plaintiff will entitle the defendant to a reduction of damages unless it amounts to the sort of conduct which, prior to the enactment of the Contributory Negligence Act, would have afforded the defence of contributory negligence. And so what he's doing there is he's focusing not on the causes of action, but the nature of the conduct. And if the nature of the conduct is such that it could have given rise to a defence of contributory negligence in tort, then it's available in concurrent liability claims. And in terms of the interpretation of the Act, we would invite your lordships to look at the texts that we set out at footnotes 12 and 13 of our case. So that is So that is, firstly, the Burroughs, as he then was, on remedies for tort, breach of contract and equitable wrongs. And that's at page 140, which we have at 9590. And also the influential article by Professor Jane Swanton, entitled Contributory Negligence as a Defence to Actions for Breach of Contract, and that's at page 281 in the left-hand column, which is MS 9905. And maybe, although pressed for time, I can just very quickly look at what Lord Burroughs said. So going to page 959. What Lord Burroughs says there, starting the second full paragraph. However, at least two alternative interpretations, according to which the second limb sometimes does apply to breach of contract, even accepting that contributory negligence was not a defence to breach of contract at common law. One of these, or an equivalent, must have been adopted in Rowe and Turner and Vester and Butcher. The first is that where the defendant is concurrently liable in tort, then if the claimant's conduct would have been a total defence at common law to that tort, had the claimant framed its actions in tort, the action applies even though the claimant now frames its action in contract. That's what we say. You look at the nature of the conduct. The second interpretation is that it's irrelevant to consider the defendant's actual conduct or what the claimant is suing for in the instant case. Rather, the second limb refers to the claimant's conduct being of the sort that at common law would have been given rise to a defence of contributory negligence if the claimant had been suing for a cause of action to which the defence indisputably applies, e.g. the tort of negligence. On the second interpretation, the claimant's fault in the second limb is kept rigidly distinct from the defendant's fault in the first limb. And, my lords, we say that is the correct approach to the construction of the Act, to look at the nature of the conduct, not the causes of action. So it's uncontroversial that the definition of fault in both the Cayman legislation and the English legislation is in two limbs. The first limb deals with defendant fault, and the second limb with plaintiff fault. So if I can start by looking at defendant fault and looking at the Cayman legislation, which we have at MS 9518. So this is defined simply as an act creating a liability in tort. And the short point is that the legislation looks to the nature of the act and not to the cause of action. In a Category 3 case, the same act gives rise to liability in contract and tort, provided the act is such as to give rise to a liability in tort. The legislation applies even to a claim in contract based on the same act. So, to put it another way, and I'm sorry I'm having to rush this, tort law identifies or characterises the nature of the required fault. But provided the fault has those necessary characteristics, the legislation applies to claims in contract and tort. And that is how the matter was analysed by Mr. Justice Pritchard in Rowe and Turner and approved by the Court of Appeal in Vester and Butcher. And as President Cook in the New Zealand Court of Appeal in Rowe and Turner memorably put it, the Act can apply whenever negligence is an essential ingredient to the plaintiff's cause of action, whatever the source of the duty. And that's MS 6456 at the middle of the page. And then turning to the requirement of plaintiff fault, and still staying with the Cayman Act, the Act simply requires, or the legislation simply requires, an act which prior to the operation of the Act would have given rise to the defence of contributory negligence. And again, in our submission, the focus is on the nature of the plaintiff's act, not the cause of action. In a Category 3 case, if the plaintiff's fault would have given rise to a defence of contributory negligence on the tort claim, the legislation applies to apportion damages on the concurrent contract claim as well. And as Professor Swanson observes, and this is this is the article we quote at footnote 13 of our case. We have it MS 9905. If the legislation is construed in this way, then apportionment is available in cases of concurrent liability, irrespective of whether at common law contributory negligence would have been of a defence if the plaintiff had chosen to frame his action in contract rather than tort. And in our submission, Primeo's case gets off on the wrong foot, and one sees this from paragraph 8 of their case, page 2240, because they suggest that section 8.1 only applies to a liability in tort or other liability that prior to the introduction of the legislation would have given rise to a defence of contributory negligence. And in our submission, that's wrong, and it pays insufficient attention to the wording of the Act, because as we have submitted, the key trigger concepts are acts with certain characteristics defined by reference to the law of torts, not liability in tort. And that applies whether you are looking at the Cayman legislation or the English legislation. My Lords, could I just, at this point, pick up a point that my learned friend was making? My learned friend, and it's a point that my learned friend came back to this morning. My learned friend took some time yesterday to explain the changes between the Cayman Law Reform Contributory Negligence Act 1964, so that's on page 9208, which adopted the definition of fault from the English 1945 Act. He then took you to the 1977 revision, which we have at page 9182, where the words negligence, breach of statutory duty, or other act or omission was removed, and they just used the compendious word fault. Your Lordships will see from page 9182 that the revision, and one sees this at the top of the page, maybe we should just go to that, page 9182. One can see, looking from the top of the page, is consolidated and revision, published in revised form under the authority of the law revision law. And as my learned friend pointed out, this was actually dealt with by the judge at paragraph 314. That's page 176 of the judgment. And maybe I can just ask you to look at that.
Can you give the bundle reference again? The bundle reference?
Yes, it's the judgment page, at paragraph 314 at page 176. At the bottom of that paragraph, unfortunately, the word "or" was missed out of the definition, but the process of revision does not permit any substantive amendment of the law, and so the revised version of the definition must still be interpreted in the original way. So the point we're making is that the substitution of the word fault for the more compendious phrase of negligence, breach of statutory duty, etc., it was not affecting any substantive change. It couldn't do, because it was being implemented under a revising provision, and it would have been unconstitutional for it to have introduced any substantive change. And I don't need to take your lordships to it, but at page 9425, we have the law revision law, and it's paragraph 3, which makes clear that under this provision there can be no change of substantive law. So if my learned friend was trying to suggest that there was a critical distinction, I think this was the point that he was trying to get at, because the 1977 legislation introduced the word fault rather than compendious phrase that you see in the 1945 legislation. There's nothing in the point. It wasn't intended, indeed it couldn't, introduce a substantive change.
My Lord, the page number of the law revision law?
9425, and it's paragraph 3, section 3, sorry.
I'm not sure 9425 is...
9425. I hope I've got that reference, if somebody can check that reference. The third point that I was going to turn to is the suggestion that Vesta and Butcher...
Sorry, while you're still on that point, I think following from the point that you particularly pick up from Miss Justice Pritchard and the Swanton article, that one's not looking at a liability in tort, one's looking at tort to set the standard, which is to be taken as fault for the purposes of the Contributory Negligence Act. As I understand it, you say there isn't a substantive change anyway when one gets the change in wording in the Cayman Act, because it's still fulfilling the same function in the legislation, which is to provide, if you like, an objective standard which will now be taken as fault for the purposes of the Act.
Absolutely.
Yes, okay, so I just wanted to check that you followed that.
My Lords, if I could then turn to the next point, the suggestion that Vesta and Butcher has been impliedly overruled. And the first point I wanted to start by just emphasising is that my learned friend in his case suggests that he sort of questions the standing of Vesta and Butcher. We deal with this at paragraph 37 to 39 of our case, which is at page 2367. And the first point we make in response to Primeo's suggestion that the obiter dicta of Mr. Justice Hobhouse and Lord Justice O'Connor in Vesta and Butcher has never been expressly overruled, that's how my learned friend wants to put it. We say that seriously understates how Vesta has been treated over the last 35 years. And we set out at paragraph 38 that various reported occasions on which Vesta has been followed and approved, including by the House of Lords in Reeves and Standard Charter. And we give references there. As for the specific suggestion that Vesta has been impliedly overruled by two subsequent cases, we deal with this at paragraph 39 of our case. That's 2367. And the point is that neither of those cases concern situations of concurrent liability, where, to use the phrase of the New Zealand Court of Appeal in Rowe and Turner, negligence is an essential ingredient of both causes of action. So in the first case, Standard Charter, the question was whether contributory negligence could be raised by way of a defence to a claim in deceit. The claim in deceit is an intentional tort, and not surprisingly, the answer was no. It wasn't a concurrent liability case, and it's not the case that, as my learned friend was trying to suggest, that misrepresentation or a claim in negligent misstatement are concurrent. They're different acts. Similarly, in the second case, Pritchard and the Cooperative Society, there the issue was whether contributory negligence was a defence to a claim in assault. And again, perhaps not surprisingly, the answer was no. But again, there's no concurrent liability. and negligence is not an essential ingredient of a claim in assault, which of course is again an intentional tort. My lords, the fourth point that I was going to deal with is the Commonwealth position.
Incidentally, before you do, I'm afraid, pursuing a personal train of thought.
I'm sorry?
I've been pursuing a personal train of thought, and I was looking at, just as an example of a pre-1945 case, at a very well-known Scottish case in the House of Lords called, I'll just jot down my page reference, called Wilson, let's bring up the proper title, Wilson's and Clyde Coal Company and English. And it's a case that resolved what happens when vicarious liability and a rule of common employment came into conflict with one another.
Yeah.
And it's interesting because you have the questions put to the jury, which include a question about contributory negligence. And it's a claim by a minor against his employer. So one of the questions put is about contributory negligence, and that's referred to in the speeches in the House of Lords, and there's nobody expresses any surprise that contributory negligence was raised as an issue. But Lord Atkin explains that the claim is based on contract.
Right.
When he's talking in general terms, and I'll give you the case reference in a moment, but where am I? At page 78 of the, oh, it's Lord Wright, I beg your pardon, page 78 of the report. Describes the relevant obligations as obligations of a contract of employment.
Well, I'm obliged, my lord.
And the reference is, the citation is 1938 appeal cases, page 57. I dare say one could find countless examples, but that one just occurred to me.
Well, my lord, I'll castigate my juniors for not having brought that to my attention. Just in that context, Sayers and I referred to how pre-1945 concurrent liability cases were treated as claims in tort. You actually see the same in Sayers and Harlow. So that was the case about the lady climbing out of the public toilet. And my learned friend criticises it because there's not got much explicit contract reasoning. It's got some contract reasoning, but it's not very explicit. It actually completely fits into the fact pattern that I'm describing, that these concurrent liability cases were treated as cases in tort. My lord, just coming to the Commonwealth position, we deal with this paragraphs 40 to 51 of our skeleton, which is pages 2368. And at paragraph 40 of our skeleton, we took objection to how Primeo had sought to categorise the state of the law in New Zealand, because at paragraphs 46 to 50 of their case, Primeo suggested that Pritchard in Rowan Turner had held that contributory negligence was never available as a defence in contract. We've dealt with that in our skeleton at paragraph 41, because obviously Pritchard held that the defence of contributory negligence was available in Category 3 cases. But my learned friend in their reply case at paragraph 137, that's page 2352, they accept their case was wrong. On appeal in Rowan Turner, as I've already mentioned several times, the New Zealand Court of Appeal held that the Act applies whenever negligence is an essential ingredient. In Primeo's case at paragraph 51, they wrongly suggest that the New Zealand Court of Appeal in Mowat and Boyce.
It's actually Mowat. It's a Scottish surname.
Mowat. Well, since many of my mother's Shetland relatives are in New Zealand, I ought to know better. I thought it might be Mowat, but Mowat.
No, it's a variant. The usual spelling is actually with a W. This is just a variant spelling.
We set out at paragraph 43 of our case, which is page 2368, the passage where President Cook approved the English Court of Appeal's decision in Vesta. And we explained that the case remains one of the leading cases on contributory negligence in New Zealand, and it's been applied in concurrent liability cases, some of the famous auditor negligence cases, dairy containers against NZI and AP Hughes. Moving on from New Zealand to Australia, I've already, I've explained how the decision in Astley and Austrust was immediately overturned by amending legislation. Time doesn't permit me to comment on the reasoning in Astley. We summarise why it's wrong at paragraph 46 of our case. The key point is that the court erred in its construction of the Act because it failed to identify, as held in Rowe and Turner, that the Act operates by reference to the nature of the Act, not the cause of action. And finally, we cite authority showing that the Vesta analysis has been adopted by the Singapore Court of Appeal and applied in various cases in Singapore. The fifth point that I was going to deal with on this whistle-stop tour of Vesta are the policy considerations. And we deal with this at paragraph 52 of our case. That's page 2370. My Lord, I suppose my starting point is to come back to the responses to the Law Commission's 1990 working paper. None of the respondents opposed apportionment in Category 3 cases. And that, we would suggest, is in line with the instinctive reaction that where negligence is the essential ingredient in both claims, the outcome should not depend upon whether the claim is framed in contract of tort. Now, yes, of course, there are some differences that inevitably arise between claims in contract and tort because of the essential differences in the characteristics of those claims. So, for example, as regards remoteness and limitation. But those differences should be limited to situations which flow from the essential differences in the nature of the claims. In cases of concurrent liability in contract and tort, where the same essential act of negligence gives rise to both claims, there is no justification for why contributory negligence should be available as a defence in one but not in the other. Now, in Astley and in my learned friend's Skeleton, it was suggested that the position should be different in contract because the claimant has paid for the provision of services and the parties are able to allocate risk by contractual agreement. In our submission, none of those arguments are persuasive. The fact of payment we submit is more relevant to the question of how damages should be apportioned, not whether apportionment should be possible at all. And my Lord Reid, in a sense, picked up on a similar point where he asked, but isn't the promisee entitled to rely on the promisor's promise? Well, sometimes, but look at the auditor's negligence cases. there are cases where, despite the fact that you are entitled to rely upon the auditor, there is independent fault which has contributed to the damage, meaning that apportionment should be available. So we've long got past the stage where there was the notion that if the duty was to prevent the very thing, contributory negligence could never arise. And in a sense, it's a variation on that point.
And indeed, Mr. Smith seeks to pray that in aid. If the contributory negligence findings are set aside by the board, so the board has to apply that, he relies on those points
Yes.
to say the contributory negligence is reduced or nil.
Yes. Yeah. So assessment of contributory negligence is very nuanced, and of course it's going to take into account payment. It's going to take into account the nature of the duty. It's going to ask itself whether there is independent fault. But the fact that there is a contract doesn't provide a bright line for saying in no circumstances would it be appropriate to apportion. My Lord, as for the argument that, as we see in Astley, that the parties to a contract can allocate risk, there are really two key points to be made here. First, for the last 35 years, contracts have been drafted on the basis that it's not necessary to provide for fault allocation in concurrent liability cases, as that arises by Vesta. Secondly, if contracting parties do not want apportionment in concurrent liability cases, then they can provide for that in the contract. Because the proviso to Section 8 of the Cayman Act, and it's the same in the English Act, ensures that the parties' contractual bargains takes precedent. So as a result, we say that appeals to freedom of contract actually carry very little weight. The other reason, the other policy reason, we suggest that strongly supports apportionment in cases of concurrent liability is that it allows courts to make nuanced decisions in circumstances where both parties' fault has contributed to the damage suffered. So it avoids the all-or-nothing dilemma, where the claimant recovers 100% despite obvious culpability, or nothing if the court seeks to avoid that unfair outcome by resorts to arguments on causation or last opportunity, which was one of the techniques used pre-1945. So the application of apportionment to concurrent liability cases does not just work against claimants' interests. It can lead to a percentage recovery in circumstances where the court might otherwise have felt obliged to deny the claimant's case in full. And that, in our submission, is an important policy consideration which strongly supports the Vesta decision. Just very quickly, my learned friend tried to suggest that policy in Cayman might be different. Policy is the same. One can see that from the pedigree of the legislation. So, my Lord, in conclusion, Vesta is a decision of 35 years standing. It works in a fair, nuanced way. It's a logical consequence of concurrent liability in contract and tort. It receives support from around the Commonwealth. I've shown you the respondents to the Law Commission report. Nobody objected to Category 3. We say the decision should be affirmed. My Lord, those are our arguments on the point of principle. The second stage of my learned friend's argument was to say that even if Vester and Butcher is good law, the claim against R2 was not a Category 3 case. And he suggested it was either a Category 1 case or a Category 2 case. My Lord, we find Primeo's case set out at paragraphs 67, and we deal with this. Sorry, can you just give me that? And then we deal with this at paragraph 63 and following of our case. My Lords, Primeo's analysis gets off on the wrong foot. And Lord Hodge here, in his intervention yesterday, was absolutely right. We can see that Primeo, in its argument, focuses on the nature of the duties. That is the point that they make in their case at paragraph 68. And then at paragraph 71(2), they then say the indemnity provisions cannot alter the juridical nature of the ongoing suitability obligations. And then again in paragraph 71(2), Primeo emphasises that its focus is on the nature of the duty, when it says in its last sentence, it does not change the nature of the Category 1 obligations. In our submission, that is the wrong starting point, as Category 1, and I'll start with Category 1, is defined by reference to the nature of the liability, not the duty. And so can I just start by reminding the board how Category 1 was put by Mr. Justice Hobhouse in Vester, and we have that at page 4118 at letter F. And Category 1 is where the defendant's liability arises from a contractual provision which does not depend on the negligence on the part of the defendant. So, as Lord Hodge correctly recognised, the key question is whether the defendant's liability depends on negligence, not whether the duty is a fault-based duty. The second point we make, with that as the correct starting point, is that the SICA's analysis of the impact of the exoneration and indemnity provision is absolutely right. That analysis is set out by the Court of Appeal in paragraphs 492 to 494, which we have at page 365. And having posed the right question, the Court of Appeal correctly observes at paragraph 494 that R2's liability only arises because it has failed to take reasonable care. So, having reached the conclusion that R2's liability was dependent on R2's negligence, SICA, the Court of Appeal, rightly concluded that the claim against R2 was not a Category 1 case. And that reasoning also rightly led the Court of Appeal to conclude that the claim against R2 was a Category 3 case, because if you look at the definition of the Category 3 case in Vester and Butcher, It's whether the defendant's liability in contract is the same as his liability in tort, independently of the existence of the contract. So again, one sees the emphasis on liability. The third point that I would make is that even if you're against me on that, and you say I'm wrong, that the threefold categorization looks to liability rather than duty, and you say it concentrates on duty, we say that SICA would still be correct to hold that R2's claim fell within category 3. Because at paragraphs 490 and 493 of the judgment at page 365, the Court of Appeal made the obvious point, supported by authority, that the contract has to be construed holistically. And that the Court of Appeal rightly concluded that when you look at the liability provisions and the exoneration provisions, it means that R2's liability only arises because it failed to exercise reasonable care. So it was in that context that the Court of Appeal at paragraph 494 commented, accordingly, notwithstanding what would appear to be the unqualified language and absolute terms of the most effective safeguards in clause 16b, that duty is in reality a duty to exercise reasonable skill and care in connection with the most effective safeguards. To put it round the other way, Primeo's analysis is wrong. You don't, as they suggest in their case, look at the duty issue separately from the exoneration provisions and ask if the latter can change the, as they put it, juristic nature of the duty. The holistic contract analysis requires the one to be interpreted in the light of the other. The fourth point, which I would just like to elaborate on, is that Primeo, in any event, have mischaracterized, at least in their case, the character of the clause 16b duty. And that there are two points really that I'd like to bring out. First, the clause 16b duty was not an obligation to bring about a certain result. That's how it was put in Primeo's case, and one can understand why, because they wanted to try and suggest that this was a case like Barclays and Fairclough. But in oral submission, my learned friend recognised that that wasn't the obligation. It wasn't to bring about a certain result. It was to make a recommendation. And we see that from paragraph 193 of Mr. Justice Jones's judgment. And it's the last two sentences, that's page 111. It's the failure to make the recommendation which constitutes the breach. And it may be helpful if I could just provide a little background to that, because it leads to the point that you can't actually just read the wording of clause 16b and divine the nature of the duty. One of the main arguments that we put forward, which the judge rejected, was that clause 16b only applied to what is known as network custodians. So a sub-custodian, which is part of HSBC's group of local custodians. So we said it could only apply to a network custodian and not a sub-custodian such as Blimis, which had been introduced by Primeo. It was in a direct contractual relationship with Primeo because Blimis was acting as the broker-dealer and investment advisor. And the basic point is that where one has a network custodian, the ultimate client will have no contractual relationship with that network custodian. The only contractual relationship is between the custodian, R2, and the sub-custodian. And the construction point we made was that with a network custodian, R2 would have been in a position to require the custodian to implement whatever safeguards they wanted. Because as I've said, a network custodian would have no relationship with the ultimate client, but that was not the case here. So Primeo had a direct contractual relationship with Blimis, such that in terms of a most effective safeguard, we couldn't simply remove Madoff as the sub-custodian. Normally, with a network sub-custodian, the client wouldn't even know who the sub-custodian was, and we could remove the sub-custodian. But we couldn't do that with Blimis because of the contractual relationship that it had with Primeo, and that it was an essential feature of the Blimis type of investment that Madoff should be the sub-custodian. So it was for that reason that we were saying to the judge, clause 16b can't be applied to a situation where Blimis is fulfilling a tripartite function. And the judge's solution to that problem was not to say clause 16b doesn't apply at all. He said clause 16b requires you to make a recommendation. So that's the genesis of why the seemingly absolute obligation in clause 16b becomes simply a duty to recommend. The second point is that the judge rightly held, even in the context of obligations to make recommendations as to most effective safeguards, that the obligation was simply an obligation to exercise reasonable skill and care. And that, we submit, is self-evident from how the learned judge expressed himself. And can I, in that context, can I just ask you to look at paragraph 302, which we have at page 167. And paragraph 302, as you can see, it starts by referring to clause 16b and referring to the continuing supervisory and the ongoing suitability duties and the most effective safeguards duties. And then at the bottom of that page, he says, this leads me to the conclusion. Oh, I'm sorry, it's in the middle of the page in 302, where he says, I agree with Mr. Gillis that on its true construction, clause 16b imports the standard of the reasonable, competent global custodian. So he was accepting that those duties were subject to a due care standard. And one sees the same point at paragraph 322, which we have at page 180. And again, references to the ongoing duties to satisfy itself about the ongoing suitability of Blimis as sub-custodian and to require Blimis to implement the most effective safeguards available under the laws. And then he goes on to say it is an implied term of the contract, and in performing these duties, HSSL will exercise the care and skill to be expected of a reasonable, competent custodian. So that is the clear finding which the judge made as to the nature of the duty that was owed. And in that context, can I just ask you to look very briefly at clause 16b itself, which we have at page 449. And the point that we would make under clause 16b is that in terms of an express obligation to exercise due care, that is only in respect of the appointment of suitable sub-custodians. So that's the only obligation which is expressly expressed as being subject to an obligation to exercise due care. The ongoing supervision obligations and the most effective safeguards are not expressed to be subject to that standard. But as I've shown you, that was the conclusion that the judge rightly came to, that the due care standard applies to all three limbs. Now, and just for your information, I don't need the court to turn it up, but if you look at footnote 44 to the judge's judgment, he explains that the most effective safeguard standards is actually something that is just listed from, taken from the Irish listing rules. What page is that? So that's the origin of that provision. I'm sorry, I'll get the reference at the moment. Now,
it's on page 97.
I'm much obliged. I'm much obliged. So this wasn't some sort of bespoke provision that was inserted. It was just from a requirement of Irish listing. Now, again, if I can go back to paragraph 178 of the judge's judgment, at page 101. And now go on to consider whether HSSL is in breach of its own duties under clause B in respect of appointment and ongoing supervision. And then, if you go down to the bottom of that page, one sees that he then says the key issue is whether a reasonable, competent global custodian would have made and thereafter continued the appointment without requiring or at least recommending. And then he sets out what could be called the most effective safeguards. So, separate account, ID confirm. So we say that one can see very clearly from how the judge has expressed himself in paragraph 178 that he is applying the due care test to all aspects of the clause 16b duty. So it's in that sense that one needs to understand clause 16b. So it can't just be interpreted literally. So, of course, the most effective safeguards would just have been to remove Blims as the sub-custodian. That's not something we could do. And what the judge did, we give the references in our case at paragraph 67 at subparagraph 2. He simply required R2 to implement procedures which he described as being straightforward, readily available, that could have easily been set up, such that our failure to do so was negligent. So that was applying the tortious standard. And just by way, we'd taken the court to authority to show that typically professional service contracts are not construed as imposing absolute obligations, rather they're to exercise due care and skill, and we say the judge rightly accepted that. In actual fact, footnote 20 to our case before the board, at page 2373, we refer to some of those, that authority. Now, a learned friend pointed out that in the judgment at paragraph 317, the judge held that R2 was not a Category 3 case, because the most effective standards duty was not a duty to exercise reasonable care. So that's at page 178, and that's paragraph 317 that my learned friend took the court to yesterday. And that's right, that's what the judge did seem to indicate at paragraph 317. The point is, that was the basis of our appeal, because we said that the judge's finding there conflicts with his other findings that I've taken the court through. Now, before the Court of Appeal, we can see in the last sentence of paragraph 488, so that's at page 384, sorry, 364. In the last sentence there, the Court of Appeal says, it does not, however, necessarily follow that that because the appointment and ongoing suitability duties are only to use due care, that the most effective safeguard duty also does. So the Court of Appeal didn't actually resolve the issue, because as we can see from paragraph 490, page 365, the court took the holistic view, namely that the contract has to be viewed as a whole, including the exoneration provisions, and so they held that it was a Category 3 case by looking at that. But if necessary, we maintain that the judge did find that all aspects of Clause 16b were subject to the due care requirement, and that's what he stated at paragraph 302 and 3022. So, my Lord, those are what I was going to say about Category 1. If I'm going to have the court's indulgence for 5 minutes, and I'll deal with Category 2, and then I'm finished with contributory negligence, or would the court prefer to rise?
I think we had better adjourn just now, Mr. Gillis, and we'll resume at 2 o'clock.
Thank you.
Oh, just before we rise, I should say that my arithmetic is that you were 2 hours late in starting, and unless anybody corrects my arithmetic, I'll proceed on the basis that you're therefore entitled to go on for 2 hours longer than you'd indented for, which would take you to 3 o'clock tomorrow.
I'm obliged.
Very well.